Good evening, ladies and gentlemen. Tonight is session number 15 for the University of Visayas Goliath Law School Operation Bar Excellence. Tonight we will discuss certification election, representation issue, appropriate bargaining unit, bars to certification election, including the contract bar, the deadlock bar, 1 year post-election bar, and other subject matters in Book 5 of the Labor Code. Bargaining unit defined, because many students are not aware that in a company there can be more than one bargaining unit. Immediately there will be two: the bargaining unit of the rank and file and the bargaining unit of the supervisors. So even if you have few employees, we cannot mix the supervisors and the employees. They have different, not just different unions, but different bargaining units. Because in one bargaining unit, there can be 5 unions, because only 20% of the bargaining unit can form a union. So the first criteria is, are the employees bound together by mutuality of interest? When I worked for San Miguel for 12 years, from 1986 to 1997 to 1998, San Miguel had multiple bargaining units. Just imagine here in Mandaue, that was only one company before. There is a packaging group that are manufacturing glasses. There is a beer group. There are Magnolia Poultry. They are also San Miguel. So because of lack of mutuality of interest, the poultry people cannot join the beer people, although they belong to the same company. Only one juridical personality is their employer, but because they do not have mutuality of interest, they have different wage structures, different wage levels, not just different locations, but different lines of business. So they cannot be together in one appropriate bargaining unit, yung ABU, appropriate bargaining unit. And so if assuming they are one bargaining unit, all those who are in beer, we have a union for rank and file, and the supervisors can form their own bargaining unit. So it is possible that there are 10 unions in beer alone, because there will be 5 unions for the bargaining unit of the rank and file, and 5 unions in the bargaining unit of the supervisor. So you do not be confused about it. No? So you always look at this. The executives and the managers plus the confidential employees are excluded. The supervisors are not excluded, they are only separated. And the rest are rank and file. So it's possible there are 4 unions, A, B, and C, and D, and the group of non-unionized people, especially if by religious affiliation they are not allowed to join union. So although they are not union members, they are members of the bargaining unit. Do not confuse the two, because the concept of a bargaining unit is different from a concept of a union. If you are an employee, you do not have to give your consent to be a part of the bargaining unit. But to be part of the union, normally, you join the union voluntarily. Good afternoon, Dr. Velasco. Welcome again. I'm happy that you keep your interest even if UB is not unionized, but who knows in the future, no? We cannot really tell, and you will be the only expert together with HR, no? So, yeah. So, you have heard of the term intra-union and inter-union. So, minsan mako-confuse kayo dyan. So, para hindi kayo ma-confuse, just remember the intramurals. The intramurals of UB, taga-UB lang yan. Pag interscholastic na, lalaban na tayo sa San Jose, San Carlos. So, pag intra-union, it is a dispute within one union. For instance, they are quarreling about money, union fund. They want to impeach the treasurer. That's an intra-union dispute. And the NLRC would have no jurisdiction over this dispute. The labor arbiter has no jurisdiction over this dispute. This is an intra-union and inter-union, and this is under the jurisdiction of the med-arbiter. The med-arbiter is mediator-arbiter, and this is a lower position compared to the labor arbiter, because the labor arbiter is a presidential appointee, equal to the rank of an RTC judge. A med-arbiter is just appointed by the Secretary of Labor with lower job grade. But he has also an adjudicatory power to decide on intra-union and inter-union dispute. So pag inter-union, lalo na, halimbawa, Union A versus Union B, they are fighting for supremacy within the same within the same bargaining unit. Union A versus Union B versus Union C versus Union D. They are all fighting, and that is already an inter-union. It's no longer an intra-union. Because if it is an intra-union, it is confined to one union. They want to impeach the president. They want to expel a member for union disloyalty. That is an intra-union dispute. No? So, cancellation of registration of a union is an intra-union dispute. Election of officer is an intra-union dispute. If there is a protest, no, or audit of financial accounts, isipin lang ninyo na dalawa lang ang paglalabanan sa union: pera at power. Yun ang palagi kong sinasabi, dalawang P, may pangatlong P. Hindi ko lang masasabi, pero ang masasabi ko lang pag-ibig. Pag nag-aaway tungkol sa pag-ibig, kahit sa union o sa hindi sa union, magkagulo na. Sa mundo, ang pagkaguluhan sa mundo, tatlo lang: power and pera, no? Peso and politics. Yun lang pag-uusapan, no? At saka pag-ibig. Lahat na yan, nilista ko dyan. Yung mga nilista ko dyan, those are within the jurisdiction of the med-arbiter. No. Now, what is this? This is the result of the amendment to the Labor Code introduced by one Bisayanian by the name of Ernesto Boy Herrera. He was the one who created this, which made it more difficult for us. Bakit? Kasi dati sa Labor Code, from 1974 to 1989, 74 to 89 is about 15 years. simple lang, 3 years lang lahat. 3 years yung economic, 3 years yung representation. So madalas ang eleksyon noon, madalas every 3 years. Election ng bargaining agent, hindi election ng officer ng union. Ang election of bargaining agent is called certification election, which is an inter-union dispute. Kasi ang election of officer is intra-union dispute. So yung mga nakita ninyong red, yun ang freedom period, 60 days. Last 60 days, every 5 years, is the freedom period, and that is the only time where you can question the status of the bargaining agent, which is the SEBA, sole and exclusive bargaining agent. Outside that period, an election petition is not entertained because of the contract bar rule. There is a bar against election when there is an existing contract. The contract is the CBA. When the CBA is there, you cannot have an election. That's why after 3 years, although there is a CBA negotiation for the economics, you do not have an election. Only you have to wait on the 5th year, no, to have a chance to either re-elect the incumbent or change him, or change the incumbent with a new bargaining agent. Well, if you remember this case of Bank of PI, which involved the merger of Far East Bank and Bank of PI, there were 2 unions here. The union of Far East Bank and the union of Bank of PI. According to the law on merger and consolidation, when 2 companies merge, only one will remain. And so, the Far East Bank lost its existence. Only the Bank of PI remained. So what happens to the employees of Far East Bank? According to the Supreme Court, in bank, no, they should be absorbed by the surviving company, which is BPI. Now, since BPI had a union and all employees are duty-bound to join the union because of the union shop provision in the CBA, the Supreme Court said that all the employees of Far East Bank, they have lost their employer, they have lost their union, they are now new employees, they have to join the union of Bank of PI, which is Associated Labor Union. And failure on their part to do so within a deadline set by the CBA would mean that the ALO as bargaining agent or as SEBA has the right to demand on management to terminate the services of those who refuse to become member of the bargaining agent. And that is upheld by the Supreme Court. And if they say that we have the right to not to join, because according to them the right to join includes the right not to join, the Supreme Court said that right not to join is subordinate to the right to join, because unionism is a national policy. The state promotes unionism, and therefore failure to join is a ground for termination, except only if they invoke religious reason. Pag religious kasi parang kaso ng Ibralinag case yan na sinabi ng Supreme Court that freedom of religion is superior to other freedoms, no? So the superior freedom, pag religion ang sinabi, hindi na sila matatamaan, hindi sila matatanggal sa trabaho because religion ang in-invoke Parang kuan yan parang sa Badista na if you have a Seventh-day Adventist employee and you force him to work on Saturday and refusal on his part, you issue a disciplinary action for insubordination, that action would be nullified by the Supreme Court because the reason is religious. The reason is religious, and he can invoke that reason, and that would excuse him from reporting on Saturday. But of course, if he is a daily paid employee, that means he does not receive wage because he did not work on Saturday. The employer is not duty bound to pay him wage, except if he is a monthly paid employee, because a monthly paid employee is already paid the whole month, no? But a daily paid and does not work on Saturday is not entitled to pay for that day. Now, mixture is no longer a ground to cancel. The cases of Tagaytay Highlands and the Toyota case are now abandoned by the Supreme Court. So even if there is a supervisor who surreptitiously joined the rank and file, intentionally, whether intentionally or out of simple error in judgment, the supervisor would just be expelled from the union. But that is not a ground to cancel the certificate of registration of the union. Because of Republic Act 9481, which President JMA did not approve, but it lapsed into law on June 14, 2007, this is in effect an amendment of the Labor Code. And it is an abandonment of the precedent in Toyota Highlands, in Toyota Company and Tagaytay Highlands. So, now, if under Republic Act 9481, as explained by the Supreme Court in the case of Charter Chemicals, the Federation can issue a charter to the local, and even if the charter is not under oath, as long as the local union secretary or treasurer signed it and attested by the local union president, that is enough for that local to acquire a juridical personality for a limited purpose, which is for the filing of a certificate of registration. So pwede na ngayon mag-file ng petition for certification election kahit hindi na-register ang local sa DOLE. Yung charter na ibinigay ng federasyon is equivalent to registration. But once there is certification election, whether it wins or not, that juridical personality is no longer available for purposes of exercise of other rights like the right to own property, the right to sue and be sued, the right to be exempted from taxation. That cannot be granted to a chartered local without a registration. So registration is still necessary. The failure to submit financial reports is no longer a ground to cancel Legion International versus Kilusang Manggagawa. Yan. Because the policy of the state is to make it more difficult to cancel, because the basic principle is to promote unionism, make cancellation more difficult. Constitutional policy to afford full protection to labor takes precedence over police power to regulate union activities. So this is one case where full protection to labor is higher in hierarchy than police power. So yung mga power of the Secretary of Labor to audit union funds, no, and to regulate union activities should not be higher than the mandate of the Constitution to afford full protection to labor. No? So, yung mga dole officials should go slowly when there is a petition to cancel. They should not run roughshod or be reckless in just canceling left and right, because that would go against the basic policy, which is to promote unionism. Hasty cancellation negates protection to labor and neglect social justice. So here, napagsabihan ng Supreme Court ang mga taga-dole. Kayo mga taga-dole, huwag kayong masyadong nagmamadali na mag-cancel. You have to exercise extraordinary diligence. Dahil pag ginawa ninyo yan, kinalaban ninyo yung the very objective of Article 218, Declaration of Policy, which is to promote free collective bargaining. How can there be bargaining if there are no more unions? Because you have cancelled them. Ang trend nga is to liberalize unionism. Tapos ang gagawin naman nyo, cancel kayo ng cancel. You are against the flow of the current of legislation that is addressed to the DOLE and the Bureau of Labor Relations. Because cancellation is like the death sentence. When you cancel a union, it loses its life and juridical personality. So it is against policy. Now, collateral attack. What is the meaning of collateral attack? If there is a petition for certification election filed by Union A and the company is summoned to attend the hearing before the med-arbiter in the regional office, the management or any other party cannot file a pleading asking for the dismissal of the petition for certification election because they are going to file a cancellation against the petitioner union. Cancellation, if I am the union, you want to cancel me, you file another case of cancellation. Do not ride here in this case of petition for certification election. Yung lahat na gustong makancel ang isang union who happens to be the petitioner in a certification election cannot ambush, cannot collaterally attack by filing a motion to dismiss the petition for certification election on the ground that the petitioner union should be cancelled. The cancellation should go in another proceeding. This is independent, no? And even if there is already a decision to cancel, if that decision is not final and executory because it is being appealed, then election should continue. And if the petitioner wins in the certification election, then he should be certified and collective bargaining should follow. Yung mga style ng ibang management para lang ma-defeated yung pag-uunyon, papailan ng cancellation. Kaya nga ginawa ng amendment ang labor code Even if there is a pending petition for cancellation, the petition for certification election should proceed because there is no prejudicial question. The council for the management cannot say, Your Honor, we have to suspend this proceeding of certification election because there is a sword of Damocles hanging on the head of the union. For all we know, this union, which is asking for an election, will lose its juridical personality. Then the hearing officer, the mid-arbiter, should say, I don't care. We will proceed unless we are restrained or there is an injunction against us. We will continue to hold certification election because it is the policy of the Labor Code to expedite petitions for certification election so that there will be a bargaining agent and bargaining agreement can be negotiated thereafter. Yan. This is a case which I have researched very recently, dated February 4, 2019. Take note ha, last year lang ito, na ang isang empleyado nagtayo ng union, labanan yung incumbent union, pero hindi niya hinintay yung freedom period. That is wrong. Because in the first place, that attempt is not going to be entertained. And that action on the part of this employee by the name of Venerando Nuya was considered under the Constitution and bylaws of the union as union disloyalty. Can you imagine you are a member of the bargaining agent union and you are organizing another union asking for the signature of employees to fight and contest the right of the incumbent to represent the employees in the bargaining unit. That is out of tune. That is out of order. And not only that, Venerando Nuya was expelled by the union, and after expulsion, the union asked for his termination. And here, management terminated his services. And that was questioned. The Supreme Court upheld the validity of the action on to terminate Nuya because the validity of union shop is well recognized in this jurisdiction. It is a settled issue that when you are expelled from your union and there is a maintenance of membership shop, part of the union shop, which means you are compelled to remain as a member of the union in good standing during the lifetime of the contract, except only during the freedom period. That is the only time you can resign. But if not, you will stand to face the consequences as what happened here. Also in this case of United Polyresins, it is the considered view, no, that the company is liable for, kasi ang kasalanan naman dito, pag ikaw management ka tapos nagdemand ang union na tanggalin yung tao, be sure that the person should be given due process. It should not be automatic. Hindi yung magmamadali kang tanggalin kasi diniman ng union. Unang-una, dalawa ang due process dito eh. Due process sa union, nung bago ka in-expel, binigyan ka ba ng opportunity ng union to explain? Now, assuming na tapos na yung union proceedings, ngayon, mag-demand on the management to terminate, he should also be given another opportunity to be heard. It's not automatic. Kaya nga nagkamali itong mga management dito kasi ginawa nila automatic eh. By the way, 7 na lang ang kulang, maging 1,000 na ang subscriber ko. So ang pakiusap ko sa inyo, please make it 1,000 tonight. 7 lang kailangan eh. Just type the word USEC GBJ and you like, you comment, ang makuha nyo dyan, you have free access to all the videos. Itong mga lecture ko dito sa UV at sa iba ko pang lecture, sa dami-dami, more than 20 videos na you can access kasi parang pag kayo napagod na, ayaw nyo magbasa, makinig na lang kayo sa YouTube. Makinig kayo sa mga lecture ko habang kayo nagpauraray sa kandungan ng inyong minamahal. Makinig kayo sa aking lecture doon sa video. Pero makuha lang ninyo yan kung mag-subscribe kayo. Diba? Wala naman akong hinihingi sa inyo eh. No? Wala akong hinihingi sa inyo, yun lang. No? So, yung ba naman, ipagkait pa nyo sa akin. Okay. Nandito tayo ngayon sa 4, 5, and 6. To form a union, you need a constitution and bylaws. You elect your officer. You prepare the minutes. And then, number 5, you register it so that the union becomes LLO, legitimate labor organization. Now, how do we become a SEBA, sole and exclusive bargaining agent? We have to file a petition for certification election, or we can be granted voluntary recognition by management. Kasi kung ikaw ba naman management, 100 ang empleyado mo, puro rank and file. Binilang mo rank and file, 100. Out of 100, 92 yung nakapirma na mag-join sila sa union. Tapos magpa-eleksyon ka pa na klaro man talagang may overwhelming support yun. So, ang management sabi, wala na, inevitable na talaga na mag-form ng union. So, kaysa mag-eleksyon pa tayo, gubot pa, dugay pa, we are giving you recognition. Kasi wala namang ibang union eh, kayo lang eh. So, we are giving you a recognition. And that recognition will be registered with DOLE. That is equivalent to having won in an election. And the next will be going to number 7, which is collective bargaining. Yun ang proseso dyan eh. No? So, pag halimbawa walang recognition, so we are now facing a representation issue. If you are asked this question by the bar examiner, you have a general question. What is a representation issue? Yung mga hindi nag-aaral ng labor relation, hindi nila maintindihan what is a representation issue. It is a decision or a question addressed to a group of employees, whether rank and file or supervisory. And the decision can be divided into 2 questions. Number 1 question, do you want to be represented by a union for purposes of collective bargaining? That's the first question kasi kung ang answer mo doon, no, we don't want a union, di tapos na. The people do not want representation. Talo na yung petitioner na union. Pero pag ang answer niyan sa first question ay yes, then the second question is, which union do you want to represent? Kung isa lang ang petitioner, di wala nang ibang choice. Pero pag marami, Union A, Union B, Union C, checkan mo yung gusto mo. And this question can be resolved by any of the methods provided by law. And the employer should not participate in the resolution of this issue. So, kayong mga employer, tulad ni Dr. Velasco, lalapitan kayo ng mga rank and file, ma'am. Doktor, saan kami bubuto? Sinong ibubuto namin? Well, dapat ang sagot dyan, that is your own decision. Management will not interfere because we have the bystander rule. Ano yung bystander rule? We are just a bystander and we are non-partisan. No? Hindi nga, ma'am. Sino ba talagang gusto ng management? Meron talagang gusto ng management eh. Ayaw lang namin sabihin, pero kung pilitin nyo kami, ang gusto namin sana yung Union A kasi ayaw namin KMU, ayaw namin yung mga magugulo. Pero wish lang namin yan. That is not unfair labor practice, hindi yan nangangampanya. Nag-express lang siya ng desire. Parang kuan yan eh, parang government employee. Government employee ka, halimbawa, career ka, civil service eligible, hindi ka political appointee. Tapos nagtrabaho ka sa Capitol. Tanong ka, sino ang gusto mo? Si Gwen o si Junjun? Sabi, hindi ka dapat magiging partisan kasi government employee ka eh. Pero tinanong ka eh, sabi niya, ako, Junjun talaga ako kasi taga Argao ako eh, ako buutan ka yung bata. No? That is not campaigning. You are just expressing your own view or wish, no? So you cannot be charged of electioneering by doing that. That is in political law, no? Election code yan eh. Pero dito sa labor law, when management expresses its own choice but does not exercise moral ascendancy or actively campaign or compel an employee or threaten, pag hindi kayo bumoto nito si Union 8, tatagalin ko kayo, mga linti kayo. Ganon. Hindi pwede yan. That is already unfair labor practice. No? How is representation issue properly resolved? Merong 5 paraan. Ito certification election is the most common. And there is a definition there. Secret ballot. And one of the choices is always no union. Kahit isa lang petitioner, Union A versus no union. And that cannot be decided viva voce. It should be decided through secret ballot. No? Consent election, iba yung certification election kasi ordered by DOLE yun eh. Bakit ordered by DOLE? Kasi nag-file yung union sa DOLE. And after finding na all the requirements are complied with, mag-order na yung DOLE for holding of CE, certification election. Pero pag, halimbawa, sabi ng management, ako nasayod ba ako ninyo nga kamo gusto mo mag-eleksyon, gusto ko lang ipahibalo ninyo nga wala kami objection, pwede na kayong mag-eleksyon, no? So the DOLE does not have to issue an order. The agreement of Union A, Union B, Union C, or isang union lang, union at saka management, nag-agree sila, magkaroon ng secret ballot, no? Pero magpahibalo kaya po na sa DOLE, kaya ang DOLE may mo prepare sa ballot, ang DOLE mo conduct, magdalag ballot box, no? So, pahibalo na lang, but it is not the order of the DOLE, it is the consent. That is the only difference. It's still the same, it's still the same process. Yung rerun, ano naman yung rerun? Iba yun sa run-off. Kaya kayo, ma-confuse kayo sa run-off at saka rerun. Ang rerun kasi, 100 empleyado, ang bumoto lang 48. 48 lang. Bakit hindi bumoto yung iba? Kasi binigyan ng pera ni Ma'am Velasco, pinapapunta sa daan bantayan. Paano makaboto yan? So, ang majority wala. So, ang tawag noon, failure of election. No? Kung tiguang na, failure of erection. No? Failure of erection. Pero, pag labor union, failure of election. Kasi less than 50% dapat 51% ang bumoto para maging valid ang eleksyon. No? Assuming 51 ang bumoto, ang daming participant, Union A, Union B, Union C. Tapos 51 ang bumoto. No, not one of the choices got majority of the valid votes cast. Halimbawa, 51 ang bumoto, valid ang eleksyon. Tandaan nyo yan, 51 ang bumoto, 100 ang registered voters. Ang tawag ng labor code niyan, eligible voters. 100 eligible voters, 51 ang bumoto, valid ang eleksyon. Tapos, labanan sila. Walang nakakuha ng, ang valid votes lang out of 51 is 47. Kasi naging invalid yung iba. So sa 47 na yan, dapat kumuha kayo ng, anong majority ng 47? The 48 divided by 2, 24. Dapat 25. Ang winner ng union ay kailangan makakuha ng 25. Or ang no union makakuha. Because the number of valid votes cast ang bilangin. Hindi yung number of votes, but number of valid votes cast. So, kung naglabanan yan, walang nakakuha ng 25, that is run-off. Run-off ang mangyari. Hindi yan rerun. Kasi ang rerun, invalid ang eleksyon eh. Ang run-off, valid ang eleksyon eh. No? Nakuha ninyo yan ha. Yung voluntary recognition, pinaliwanag ko na yan. Who are allowed to vote in a certification election? Ayan, ito ha, number 1. All employees who are members of the appropriate bargaining unit 3 months prior to the filing of the petition. So, ang payroll master, Dr. Velasco, kung sino yung in charge ng payroll dyan sa UB, isusumon niya ng dole. Dalhin nyo ang payroll for the last 3 months. Kasi doon natin ibase kung sino ang eligible voters. Kasi yung na-hired ng kahapon, o na-hired nung isang araw, hindi yan makaboto kasi ang amendment sa Department Order number 40, 03, number 15 na ngayon, 4003, no? Ang original 4003, amended by DO 40-15. In other words, yung ginawa ni Secretary ng Labor noong 2003, inamend noong 2015. Ano ba yung DO? That is the Department Order implementing the Labor Code. And that is a valid delegation of quasi-legislative power by virtue of Article 5 of the Labor Code. Okay? So, inamend nila ngayon na para walang gulo baka ang gagawin ng management mag-hire patapos pabutuhin ng no union. Kailangan lang 3 months backward lang ang bubuto. Pangalawa, kung tinanggal ka ng iyong company last month pero nasa payroll ka 3 months ago, tinanggal ka last month, nag-file ka ng kaso illegal dismissal, pending ang kaso, you are still allowed to vote. Kahit natalo ka na sa labor arbiter, pero nag-appeal ka, wala pang final and executory, makaboto ka pa rin. But if there is a final decision declaring that the dismissal was legal, he will no longer be allowed to vote. Now, ngayon, maglaban-laban ngayon doon. Sabihin ng representative ng Union A, kailangan pabutuhin yan. Sabi ng Union B, pati management, hindi pwedeng bumuto yan. Paano mag-ruling? Mag-ruling ngayon ang election officer. Election officer is representative of DOLE. Ang ruling niya ganito, pabotohin pero isiparate yung kanyang boto. Ilagay sa envelope, pirmahan natin lahat. Hindi natin yan bilangin. Bibilangin lang natin yan if the result of the election is so close that that ballot will make a difference. Halimbawa, nag-tie ngayon. So, kailangan buksan natin yung contested ballot. And then the mid-arbiter will make a decision to count or not to count. Ngayon, kung ikaw, prejudice ka, natalo ka dahil sa isang boto, you just say for the minutes. Kasi ang eleksyon may minutes eh. We would like to make of record that we are going to file a protest. And that protest must be formalized within 5 days from the time of the holding of the election. I hope that I make myself clear. What is the proper timing for the filing of the petition? Yun ang sinabi ko eh. When there is no CBA, walang union, ngayon lang nagkaroon, walang limit, walang lahat ng araw freedom period, walang ibang union eh, wala ding CBA existing. So anong problema? We have to we can file immediately petition for certification. When there is a CBA, wait for the freedom period. When there is a 1-year bar, halimbawa, kanina, sinabi ko nagkaroon ng failure of election, nagkaroon ng valid election, katapos nagkaroon ng runoff. Tapos wala pa rin nanalo. You have to wait for 1 year bago ka mag-file uli. And when there is an ongoing CBA negotiation, halimbawa, merong ginawa ang management eh. Ang gusto ng management yung incumbent. Sabi na, nag-file tayo ng petition for certification election. Ang incumbent kasi, sabihin ko sa inyo, hindi siya nagpa-file. Alam niyo kung bakit? Ikaw ang incumbent. Pag walang magpa-file, you are deemed re-elected. Bakit mo guguluhin para magkaroon ng election? You are already deemed re-elected if nobody will file. So, ang incumbent, hindi yan nagpa-file. Ang nagpa-file dyan is another union that wants to contest the incumbent. No? Now, halimbawa, yung incumbent at ang management, next month pa yung freedom period, sabi ng management, sabi ng incumbent, mag-negotiate na tayo. Anyway, pag merong mag-contest, ay hintayin natin ang order ng dole. Kung merong mag-contest, ang nanalo yung oposisyon, anong gagawin natin sa CBA? Habang there is no injunction, habang walang final judgment declaring the new union as the winner, kasi ang incumbent mag-a-appeal yan eh. Halimbawa, natalo ang incumbent. Tapos gusto nang umupo yung bago, mag-a-appeal pa yung incumbent. And while the appeal is pending, merong tinatawag equity of the incumbent. So the incumbent will continue to negotiate the CBA until there will be a final judgment. Abutin pang 5 taon sa Supreme Court yan eh. Pero kung ang management magpabatigas, sabi ng management, why should I negotiate with you when you have already lost? I will not negotiate. O, di ba? O, ngayon, kakasuhan mo yung management for refusal to negotiate. Umidepensa ang management eh. We are in good faith. We don't want to negotiate with a party that has already lost. Even if he has appealed his failure to be re-elected, the fact is he has no more mandate from the people. Therefore, I will not negotiate. Ganon ang gusto ng management. Walang negotiation. So, walang increase. Walang increase yan. Because there is an ongoing negotiation. Ano hindi pa na, or walang negotiation. Or assuming itong number 5, there is a negotiation but it reached a deadlock. Deadlock. Tapos magpapile yung bago. the Dole will not hold an election because there is a bar by deadlock. Ito yung apat na bar. The first is contract bar. What is contract bar? Bar means prevent. In other words, the contract will prevent the holding of an election because there is an existing contract. You wait for the freedom period because during the freedom period, there is no more bar. Pangalawa, yung deadlock bar. There was a negotiation, it reached a deadlock. We cannot hold a certification election because there is a deadlock. Yung 1 year post with the SEBA has entered into a valid certification election.
Nice.
And there is an appeal. You cannot hold a certification election within 1 year from the last. Validly ha. Kasi pag rerun lang, you do not have to wait. You don't have to wait for 1 year if it is a rerun. 6 months lang ang kailangan noon bago magkaroon ng election yung rerun. What are the problems here? Number 1 problem, the bystander rule. What is meant by that? You management, you should not campaign. You should not use your management prerogative, transferring, promoting, discipline, in order to coerce or to persuade the employee to vote no union or for one union, whatever. You should be a bystander and you have no active participation. Next problem. Before the election, the mid-arbiter or the election officer will call for a pre-election conference. Ano bang purpose ang pre-election conference? Doon desisyonan ang final list of voters. Halimbawa, sabihin ng management, ito hindi dapat yan because he is an employee of the agency, not an employee of our company. Oh. So, lilinisin yung yung list of voters at saka ipapublish yan ang list of voters in 3 conspicuous places in the company for the information of all those who will vote. So, then, during the pre-election, gagawa ng baluta. Ito lang ang baluta na permado ng Dole, permado ng management, sa likod yung baluta, permado ng Dole, permado ng management, permado ng lahat ng union, Union A, Union B, Union C, lahat, pipirma sila. And then comes the casting of the votes. No? Yan. So if there is a protest, it is verbal protest. Kasi kung hindi ka mag-protest verbally, hindi ka na makapile ng written protest. Your protest should be entered into the minutes. Be sure. No? Yung failure of election, less than majority of the eligible voters participated in the election. So I will give you an exercise, no? I hope that you will participate in this exercise, but you just check your own paper para lang maintindihan ninyo itong proseso na ito. But before we go into that, you read this provision. The provision of Article 256, which is now renumbered 256. Ang 256 na provision noon ay binigyan na ng ibang numero ngayon. No? Renumbered. CBA. Constitution ito eh. Ito. 256 prior to renumbering is now 268. So if you have a labor code, you read the second paragraph lang. Ito ha, I will read it for you. To have a valid election, and you listen to this because I'll give you a seat work. To have a valid election, at least majority of all the eligible voters in the bargaining unit must cast their votes. Sinabi lang ha, must cast their votes. Hindi ibig sabihin their votes are valid. Must cast their votes. So kung 100 employees yan, at least 51 should cast their votes. Now, that is the first majority. Kasi ito yung double majority rule. If you are asked by the bar examiner, explain the double majority rule. It means that for validity of the election, just for validity, at least majority of the eligible voters must cast their vote. It does not say they cast invalid votes. They said, it only says, must cast their votes. And second, the labor union receiving the majority of the valid votes cast shall be certified as the winner, as the exclusive bargaining agent of all the workers. So that is the second majority. Dalawa ang i-achieve mo. Una, be sure that majority of the total number of eligible voters must cast their vote. Tapos, pag na-achieve mo yan, number one, majority of the valid votes cast, kunin mo yung majority of the valid votes cast. So, let us now give you an example. And I want you to test yourself. No? Ito, apat na company. Apat na company ha. Ang unang company, lahat ng apat ng company, halimbawa, ang number 1 company is UB, number 2 company is San Carlos, number 3 company is San Jose, number 4 company is CCC or UC. Company yan. University also is a company. Okay. Pareho silang tig 1,000 rank and file employees. Pareho ha, assuming lang para madali kwentahin. Sa UB, ang bumoto 490. Sa San Carlos, ang bumoto 515. Sa San Jose, ang bumoto 501. Sa UC, ang bumoto 513. Ang unang tanong, for the three universities, was the election valid? Ang tanong ninyo dyan, ang sagot nyo dyan ay apat. Was the election in UB valid? Number 2. Which choice won? Number 3. After that, what is the next step? And number 4, who will participate in that next step? 16 lang pala, 16 points lang ito kasi 4 answer for every university. Okay? So, ready na tayo. I will now answer. Ako rin na magsagot eh. Tawagin ko kayo ito si Attorney Wagas saka si Attorney Edwin. Siya pasagutin ko. Okay. Tahimik. For UB, the election was not valid. Why? Because 490 does not constitute a majority of 1,000. And if the election is invalid, there is no winner. There is no winner. Even if Union A got 400 out of 485 votes, runaway winner si Union A. But when the election is invalid, there is no winner. And so what is the next step? No, rerun. Rerun ang next step dyan. And who will participate? All of them if they want to. Yung iba gusto mag-withdraw, bahala sila. That depends on them. Did you get that? Nakuha nila ito, Atty. Wagas? Malaman mo?
Yes po.
Oo.
Yes, attorney.
Okay, punta tayo San Carlos. The election was valid in San Carlos because 515 is a clear majority of 1,000 or among 1,000. Valid ang election. Who is the winner? No winner. Why? Because the highest vote getter, 240, did not get majority of 499. Kuha ninyo ha, simple application, ganon ang ginagawa ko sa mga estudyante ko. 499, ilan ang dapat kunin mo para makakuha ka ng majority of 499? There is a magic number, 251. 251 or 250. Basta makuha mo yung 1/2 of 499 plus 1. No? So, if there is no winner, what is the next step? Run off, hindi rerun. Run off because there was a valid election. Run off. Sino mag-participate? Only the highest two. The two unions with the highest vote. Anong sagot nyo? Union A at saka no union? No. Only Union A and Union B. Because the no union cannot participate in the runoff. Ganon din sa San Jose at saka USEC. Ganon din ang story dyan. Pareho lang yan. Valid ang USEC, valid ang San Jose. Walang winner. Ang laging maglalaban dyan ay Union A and Union B. Because the no union is not allowed to participate in a runoff. Okay, so I hope that I have explained that fully, and let us explain this case of Reyes versus Trajano. No? Itong kaso ni Reyes versus Trajano, kwanto leading case ito although this is an old case. Ito ay isang company, itong Reyes versus Trajano, isang company na pag-aari ni Mr. Lucio Tan. Ito yung company ng mga figure sa Montalban, Rizal. Tapos, ang kinuha ng company ay majority mga Iglesia ni Cristo. Assuming natin, sa isang daan na empleyado, mga 60 are Iglesia ni Cristo. Ngayon, in the past election, itong mga iglesia, hindi ito bumuboto. Hindi rin sila membro ng union. Ang naglalaban dito ay Union A versus Union B at no union. Tatlo ang pinaglalabanan. Siyempre, ang no union, yun ang favorite ng management. Kaya sila kumukuha ng mga iglesia. Ngayon, during the election, dumating yung Iglesia ni Cristo na 60. They wanted to vote. And yung dalawang union objected, we will not allow the voting of 60 Iglesia ni Cristo members because, number 1, they are not union members. Number 2, they have never voted in the past election. And number 3, if we will allow them to vote, they will vote for no union. Therefore, hindi kami mamanalos. 40 lang kami, hati-hati pa. Sila 60, solid sila eh. How did the election officer rule? Election officer naniwala doon sa union, sabi, wag nating pabutuhin yan. Ang gulo lang yan. Alam nyo, nakarating yan sa Supreme Court, led by Alex Reyes. Kinwestiyon yung desisyon ni Secretary Crescenciano Trajano. Did Crescenciano Trajano, as Secretary of Labor, in affirming the decision of the mid-arbiter, did he not commit a grave abuse of discretion by disenfranchising the members of the Iglesia? On the first issue, they are not members of any union. Sagot ng Supreme Court, you don't have to be a member of the union as long as you are member of the bargaining unit. Yan, tingnan nyo yan. Kung halimbawa, majority ang no union, mga iglesia, they are not members of any union, but they are members of the bargaining unit. Therefore, they must be allowed to vote. Because whatever is the outcome of this election will also affect them. No? Para bang part sila ng barangay natin, although hindi sila nakikialam sa ating mga activity, but they are registered resident. No? Sabat hindi natin pabutuhin yan. So sabi ng Supreme Court, mali kayo sa first issue nyo. Pangalawa, they have never voted in the past election. Sabi ng Supreme Court, meron bang batas na nagsasabi pag hindi ka bumoto in the past, you cannot vote now? If they waive the right to vote before, does not mean they are waiving it now. So, you allow them to vote. Ang pangatlo, if we will allow them to vote, they will vote for no union. Therefore, our right to self-organization will be rendered nugatory. So what? Sabi ng Supreme Court, the right to vote for a union includes the right to vote for no union, because voting for no union is also an exercise of the right to self-organization. Therefore, all the three objections are not tenable. The Supreme Court said, okay, all the 60 voters should be allowed to vote. Actually, they were allowed, but their votes were not counted. They segregated, so open the ballots and count the vote. So, what happened? Panalo ang no union, but that is only for 1 year. Pag nanalo ang no union, 1 year lang yan na ban. Up next year, pwedeng mag-file ulit. Kung ganon pa rin, paulit-ulit na lang. Ganon talaga ang buhay. The minority should respect the will of the majority. Okay, another question. Bakit nga ba yung natanggal na sa trabaho ay inaalaw pang bumoto? Natanggal na sa trabaho, wala na sa payroll yung pangalan. But they have contested the validity of their dismissal. This was answered, no, in many cases. Number one, alam ba ninyo na pag kayo ay tinanggal sa trabaho at nag-file kayo ng kaso, ang burden of proof ay nasa management. Therefore, kung pending pa ang kaso at hindi pa napatunayan ng management by final judgment na dapat kayong tanggalin, na tama yung desisyon sa pagtanggal sa inyo, then in the eyes of the law, the vinculum of relationship still exists. Pareho lang yan sa nag-file ka ng petition to annul your marriage. While the case is pending, you are still married. So it is an act of adultery or concubinage to be involved with another individual, male or female. Because ito, Tinanggal na nga yan sa trabaho pero wala pang final judgment na valid yung kanyang dismissal. At pangalawa, protection to labor ito. This provision is really to protect labor. Kasi kung hindi ito lalagyan ng ganitong provision, all that management will do is to terminate all the union members and to hire new employees. So, hindi madidefeated yung right to self-organization. Remember that it is the basic policy of the state and fundamental principle to promote unionism as an instrument for national development. Hindi ma-defeat yan sa mga dismiss. Kasi ang gagawin lang dismiss Are new employees who were hired pending appeal eligible to vote? Yes. Bagong empleyado Limbawa, nag-file ng petition for certification election January. Ginrant ng DOLE. Nag-appeal ang management. Umabot na ng October. Wala pang eleksyon. Ng month ng August, March, nag-hire ng bagong empleyado. So, those new employees are allowed to exercise the right to self-organization. Even when they were hired while the case was pending appeal. Because if you disqualify new employees, according to the Supreme Court in the case of Noreen versus Secretary of Labor, Noreen is National Union of Workers in the Hotel, Restaurant, and Allied Industries versus the Secretary of Labor. If you disqualify new employees, it would disenfranchise them, which is a violation of the Constitution, Article 13, Section 3. As well as Book 5 of the Labor Code on the right to self-organization. You cannot yan, dito tayo sa sa protest. Pag kayo nag-protest or nag-challenge, halimbawa, yung isang botante gustong bumoto, challenge ng management. Although you have a bystander rule, you can challenge or allowed to challenge. That's why management is allowed to be present during the certification election. Because you will even sign the ballot. And then, merong bumoto na hindi mo kilala. Taga saan ba ito? Ano bang lugar ito? Ba't bumoboto ito? O nag-object ka, I challenge the vote. Ilagay mo yung guns. Yan, nakita ninyo yung mnemonic device ko, guns. What is your ground for the challenge? My ground is that there is no employer-employee relationship between this person and the company. He is therefore not a part of the bargaining unit. Why should he be allowed to vote? Union or employer challenging the... So you put your name if you are the one challenging. If it is a union also challenging, the name will be challenger. The challenger should be put there. And then also the name of the voter that is being signed. And then signed, pagka kayo nag-challenge, no? Yung kanyang vote, pabotohin pa rin, pero ang boto niya, ilagay mo doon sa envelope, lagyan mo ng guns, signed by the election officer and all the representative of Union A, Union B, Union C, Union D, and the company representative. Ito yung sinabi kong double majority rule. To have a valid election, at least majority of the eligible voters must vote. Do not just say voters, it should be eligible voters. No? Yan ang problema pag kumuha ng baril, maraming kulang-kulang yung mga importanteng words nawawala So, either successful ang election, failure of election, pag failure, merong epekto. Yan. Itong runoff, merong 5 requirement ang runoff. Number 1, there was a valid election. Kanina, binigyan ko kayo ng example. Yung sa University of San Carlos. Valid yun kasi more than one half participated. And there were 3 choices. Union A, Union B, more than nga Union A, Union B, Union C, Union D, plus no union. 5 nga yun Assuming 2 lang ang union doon, A and B, plus no union. 3 na, satisfied. Pangatlo, none of the 3 choices got majority of the valid votes. Huwag yung mag-answer kay sa bar, sabihin mo yung got majority. You should say majority of the valid votes cast. Baka ma-misunderstood majority of the total votes. No! Majority of the valid votes cast. So it is possible that in a company with 100 employees, 51 voted. 51. Na invalid pa yung 3, 48 na lang. Nakakuha ka ng 25 votes. That 25 can win in a bargaining unit that is composed of 100 employees. Because nag-boycott yung 49, no? Tapos na invalid yung 3, o de konti na lang, 51 minus 3, 48 na lang yung kukuhanan mo ng majority of the valid votes, no? And the no union is eliminated. Ngayon, isa pang requirement mahirap dito, yung Union A and Union B, i-total mo yung kanilang boto, it should be at least 1/2 of the total valid votes. Total votes, not valid votes. Kasi ang votes, 51. Kailangan pag i-add mo yung Union A and Union B, must be at least, no? Majority of 51. Majority of 51 is 26. Kailangan i-add mo yung ang Union A, nakakuha na ng 25 kaya winner na siya. Pero pag 24 lang siya, tapos yung isa 24 din, tapos bumoto ng no union yung rest, wala nakakuha ng majority. Pero pag i-add mo yung dalawang union, 24 and 24, sobra na yun sa 48. That is more than 1/2 of the 51. 51 ba yun? Tama ba yun? 24 plus 24, 48. That is more than 1/2 of 51. Even probationary employees should be included. No? Yan, pag tinanong ko, what is the double majority rule? This is the answer. Double majority rule. So you have to satisfy 2 majority. The first majority is for validity of the election. At least majority of the eligible voters must vote. The second majority is majority of the valid vote cast. So that the one that gets it, whether it is a union or no union, will be declared as the winner. And there will be no more runoff. There is no more rerun if there is a winner. Because the winner takes it all. And the loser bites the dust. Okay. Ito ngayon, makapangyarihan yung mid-arbiter. Kasi pag kinwestiyon ng management, there is no employer-employee relationship between that person and the company because that person is an employee of the agency. Pag sinabi ng mid-arbiter, based on evidence, we can declare the agency as labor-only contracting. Therefore, in the eyes of the law, the real employer is the principal. He can make that ruling. And that mid-arbiter his decision is appealed directly to the Secretary of Labor, not to the regional director. Although yung mid-arbiter is under the regional director, siya ang pumipirma ng desisyon niya. At ang desisyon niya hindi nadadaan sa regional director, diretso yan sa Secretary of Labor. Yan ang story ko sa inyo kanina. Yan si Alex Reyes. Kita mo, 141 yung mga iglesia, 141, tapos yung isang union, 95, yung isa 1 lang nakuha. Spoiled vote pa, invalid yung isa. Ang bumoto, no union, may isa. So, iyang 141, hindi nila pinaboto. Ang binilang lang nila yung 95. So, dineclare nilang winner yung Olalia. But that was nullified by the Supreme Court. Because the Supreme Court said that if we count the 141, no union will come out, and therefore there was a valid election and no union won. You have to wait for another 1 year. So these are the non-union members who are members of the appropriate bargaining unit cannot be barred from participation in the certification election simply because they never voted before. That kind of argument is untenable. Yan, may consent election. What is the difference between a CE and a consent election? Isa lang yan eh. Ang CE is ordered by DOLE. So, the winner represent the entire bargaining unit. If there are 4 unions, A, B, C, and D, and A wins, A will represent everybody, including the opponents. A will represent, parang congressman ka, nanalo ka sa first district, de Golias ka, tapos yung mga kalaban mo, when you go to Congress, you also represent them. You do not only represent your supporters. So also with the union A becomes the representative of the members of B, C, and D, and even the no-union members, those who are not members of any union, because they are all part of the bargaining unit. And so if there is a collective bargaining agreement, they shall be benefited. But the non-union members should pay agency fees so that there are no free riders. If they want to be benefited from the increases in the collective bargaining agreement, they have to pay the agency fee. Pati yung membro ng B, C, D, and E, kalaban kayo, pero pag may CBA, pareho lang matatanggap natin. Magbayad kayo kasi bargaining agent ninyo ang A. Agency fee nga ang tawag niyan eh, because they are the agent, or A is the agent. Ayan, kanina na-discuss ko na. This case is very important. I want you to read this case, Holy Child School, because this is decided by the Supreme Court in Bank. This is involving an academic institution, where there was a question. There was a petition for CE filed by the union. The management filed its comments, and management said that they should not be allowed because supervisors and rank and file are all mixing up with each other. So the mid-arbiter denied the petition. The Secretary of Labor reversed the decision of the arbiter and ordered the holding of two certification election. One for the teaching personnel and another for the non-teaching. So, pagka-academic institution talaga, isiseparate mo yung teaching sa non-teaching. So, magiging apat ngayon. Sa isang universita, apat ang bargaining unit eh. Teaching, non-teaching. Pero sa teaching, merong supervisor, merong anpal. Sa non-teaching, meron ding supervisor, merong anpal. So, magiging apat yan. So, the decision of the DOLE was affirmed by both the Court of Appeals and the Supreme Court. And the first principle enunciated in that case is the bystander rule. That it is well settled in our jurisdiction that in the case of the Divine Word University, in the case of Tupas versus Trajano, that the management should be a mere bystander, non-partisan. No? The employer lacks the personality to dispute the election. Kung halimbawa, nagkakaroon ng bulilyaso yung eleksyon, hindi pwedeng mag-file ng appeal ang management. It has no personality. It is an internal question to be resolved by the members of the union themselves. Management is a stranger in paradise. Management is a bystander. No? So, ang management, darating lang yan, pipirma ng balot. Pero hindi siya magsalita kung hindi siya tanungin. No? Mixture, hindi na yan ground na i-deny mo yung certification election because of mixture. No? Wala, luma na yung mga argumento na yan. No? Collateral attack, not allowed. Yan, sinabi, collateral attack is not allowed. I explained that. Ito ang importante na dapat niyong pag-aralan. What is the difference between a union and a bargaining unit? Take note ha, there can be 5 unions in one bargaining unit. But one bargaining unit should only be in one company. Kung dalawa, meron kang dalawang company, UB at saka Freeman, di mo pwedeng i-combine yung mga tao doon sa Freeman at saka sa UB kasi they belong to different companies. Pero inside Freeman, inside UB, maaari dyan, merong 5 union sa Freeman, 5 union sa UB for one bargaining unit. Ngayon, sasabi na natin, pwedeng 4 na bargaining unit sa UB. So, 4 bargaining unit. Itigli 5 bawat bargaining unit. Di 20. Kaya dapat malalaman nyo talaga yung technical difference yan, definition of a bargaining unit. So how do you determine the appropriate bargaining unit? It is no longer the will of the party of the employees. No, number 1 is not included. Number 2 is the mutuality of interest. That is applicable. Prior bargaining history is no longer applicable. Number 4 may be added to number 2. Because iba yung temporary, iba yung provisionary, ibang bargaining unit na naman yan. Because of lack of commonality or mutuality of interest.